Welcome back to this third part of Law Sessions Co-Ownership with a focus on severance. Now, in the last segment, I flagged up for you the methods by which severance can be effected. Now, before we go into those proper, what I need us to consider for a moment is a situation where equity will automatically assume a tenancy in common. So let's say, for example, A, B, C, and D have bought a property whereby they have considered that it may be for investment purposes. And let's say the examiner sets that question for you and you now have to decide how to answer it. Well, one of the points that gets missed a lot of times is that in the context of a commercial situation, that equity will automatically assume a tenancy in common. And equity says that where, for example, the persons are partners in a trade or business, then that will mean that they are automatically tenants in common. The case for that, of course, is Lake and Craddock. Equally, if the parties have bought the property for their individual business purpose, this will also mean that equity will automatically consider that it is a tenancy in common. So taking my example, if A, B, C, and D have bought a property by way of investment, and the examiner says no more than that, because that is the point of exam questions, is to leave it with just sufficient vagueness about it for you to discuss it, you need to at least say to the examiner, well, we are not told if A, B, C, and D went into this as an investment as partners, but if that's the case, then based on their respective contributions, Lake and Craddock says that equity will automatically consider that there's a tenancy in common relative to their respective contribution. Equally, of course, let's go back. If A, B, C, and D have bought this property for their individual business purpose, so if it is that A is a doctor, and B is a lawyer, and C is an accountant, and D runs a grocery store, for example, then the point is that if they've bought the property with 4 units and they're using it for their individual business purpose, then equity says that that will automatically amount to a tenancy in common. Of course, just because you see a potential commercial situation doesn't mean you say, right, Mr. Examiner, that is the point. If they're partners, then it goes along Lake and Craddock. If it is that it is their individual business purposes, then I'm relying on the case of Malayan Credit and Jack Chia, and that is the end of it. No, because the examiner is a little bit cleverer than that, which is why he is the examiner. And what he's expecting is that after you've discussed that, you will then say, of course, the question does not make clear if it was for their particular businesses, and then you move on to say, in the event that they are not partners, or it is not for their individual business purpose, then you now focus on the general rule. And the general rule is, if the parties' names are all there at law, then it is that the parties will be, of course, joint tenants in equity, sufficiently so, especially if it is that there's a declaration. Now then, I flagged up for you in the last segment the methods by which one could sever. Now the first, of course, is section 36.2 of the LPA 1925. And that is that you can send a notice. Now this is a method by which the joint tenancy can be severed unilaterally without agreement. There is no prescribed formula under section 36.2, and a document drawn up for some other purpose may contain words sufficient to sever. As always, it is a question of fact and degree, and how the meaning of the words used are construed. The essence is that the words used must show an intention to sever the joint tenancy. That is, that each joint tenant is to have separate shares in the property. Now, it cannot be an incidental sort of situation or a by the way occurrence. So in the case of Harrison Goddard, the wife's petition to the court, a copy of which was served on the husband, for a divorce, asking the court to consider making any one of a number of possible family orders, only one of which would have involved severance, the court said there was no severance because in effect she had left the choice whether to sever to the courts to be made in the future when the order was made. Now, Section 196 of the LPA talks of service and notice in writing sent by one joint tenant to all the other joint tenants stating that he wishes to hold his interest as a tenant in common is what is required. It doesn't have to be signed. And I am considering that more often than not, and don't quote me on this, but if you think about it for a minute, it is 1925 that the legislation is drafted. And it is highly unlikely that you would have been typing this on your PC or your Mac. So it is highly likely that you would have been writing it anyway, which means that if you're writing it, it is your handwriting. That is my basic summary of it. But albeit that, the fact is the legislation doesn't require a signature. It just says that it must be in writing and that it must be delivered to other joint tenants' last known home or business address. Now, I must make one final point in relation to the Section 36.2 notice, and it is this. Sometimes in an exam, what you will get is the examiner will set up a situation where there has been severance by various other methods. So let's say A, B, C, and D, and he says A mortgages to X bank. So that's alienation. B, also by alienation. And what we get is C and D being the only remaining joint tenants. Then the examiner says to you, C wrote to D and X bank telling them that he wants to sever. Now, the point should not be lost on you. The thing is that Section 36.2 says that a notice must be given to all of the other joint tenants. The only other joint tenant in equity would be D, because C and D are the only ones still in the joint tenancy in equity. But at law, we still have A, B, C, and D. So is it that C has to give notice to A, B, C, and D? Or is it that C only needs to give notice to D? Well, in this regard, my suggestion to you, of course, would be to say that if he's written to D, it doesn't matter if he's written to A and B, because again, the maxim of equity might engage here, which says where law and equity conflicts, equity prevails. And arguably, the joint tenant in equity, the sole joint tenant in equity is D. So if he's written to D and to X bank saying he wants to sever, then the fact of the matter is X bank is irrelevant, but certainly the argument would be, did he need to give the others who are the legal joint tenants? It's a matter for you, but it is a unique point, and I would suggest you take it. Now, if we look at the second aspect to severance, a person acting on his own share. Now, although the joint tenant does not have a separate share, the law recognizes that he can separate it by alienation, converting his potential share into a separate share as a tenant in common. Now, in contrast to severance by agreement, there must be a legally effective alienation by transfer or binding contract in order to alienate. Now, this may be done voluntarily by the joint tenant who either sells his equitable interests or by mortgaging his interest to a bank. But it also may happen involuntarily. So for example, if a person becomes bankrupt, all his or her property vests in the trustees in bankruptcy for the benefit of his or her creditors. Now this includes any interest as an equitable joint tenant. So A and B, for example, are beneficial joint tenants. If B goes bankrupt, the outcome will be that A and B will hold as joint tenants on trust for A and the trustee in bankruptcy as tenants in common. The trustee in bankruptcy is then likely to be able to apply under Section 14 of the Trust of Land and Appointment of Trustees Act for an order for the property to be sold and then to release the value of B's share for the benefit of the creditors. Now, if there are more than two joint tenants, severance by alienation only operates on the severing joint tenants' interests. So if A, B, and C are equitable joint tenants, A becomes bankrupt, the outcome will be that B and C will remain joint tenants to 2/3 share of the property. The trustee in bankruptcy will have a 1/3 share as a tenant in common. Please do not put, for example, that A is now a tenant in common. He's not. It's a trustee in bankruptcy. Or if he had mortgaged it, it would have been the bank. If B were then to die, C would become the sole entitled owner in respect of the 2/3 share, by survivorship of course, and the trustee in bankruptcy would have the 1/3 share. Now when a joint tenant acts on his potential share, this will also operate to convert it into a tenancy in common. If he sells his equitable interest away, or mortgages as we said, or bankruptcy, then the equitable interest is converted into a tenancy in common. Now, other joint tenants need not know or be aware, but the thing you must always remember is that because this is an equitable interest, because remember, you would need all of the persons who are the legal owners to sell the property. But if you have one person who then encumbers their part of it by getting a mortgage, for example, or by giving a mortgage rather, and borrowing money on it, then in order for severance to be effected, it must satisfy Section 53(1)(c), which talks about a sale or disposition of an equitable interest must be in writing and signed by the person selling or disposing of the interest. This was, of course, to prevent fraud, as equitable interests were not particularly obvious. And further, Section 2 of the Law of Property Miscellaneous Provisions Act is a contract for sale or other disposition of an interest in land can only be in writing. So please make sure the point is flagged. If you hold as an equitable joint tenant, you do not have to have an interest to leave in a will. Rather, you do not have an interest to leave in a will until you have severed it. You must always sever your interest while you are alive or inter vivos. The point to remember, though, is that once severed, always severed. So even if the examiner says to you that Paul wrote to the other joint tenants that he wished to sever, but then the examiner says to you, but he decided later on he didn't want to and he stayed in the house, the fact is, severance has been effected. We will now take a short break, and after the break, we will complete with the remaining ways one can sever, and certainly complete on the Williams and Hensman methods of severance. And I ask you to stay with us for the final section.